Thank you, Professor. Thank you for the organizer for having me here. I will skip the introductory remarks given the time constraints, just by noting that it is another paradox of the common commercial policy reform and the Lisbon Treaty in general reform, the issue of national parliament democratic control on EU FTAs in principle, as the Bundesverfassungsgericht in the Lisbon Urteil noticed. There should have been no role for national parliament in the EU trade policy, and we have witnessed the opposite, actually. So, national parliament have never been so central in the legal and political debates surrounding trade policy, as I think the Wallonian saga shows very, very well. So, the presentation is divided basically in two parts, negotiation and ratification of international trade agreement concluded by the European Union. Based on an assumption that is mixity. I won't touch upon it, but I think mixity is there to stay, and this is basically the assumption on which I'm working in my presentation. So not only the relationship between national governments and national parliament, but also the role of national parliament in precisely ratification of EU trade agreement. Let's start from the negotiation. It is important to stress, first of all, that contrary to the European Parliament, in principle, national parliament, as we all know, step in after the agreement is initialed and signed, basically to ratify it according to national constitutional requirement. There is therefore a sort of subsidiarity mismatch in the sense that insofar as the agreement covers also shared competence of the Union, the Commission is obliged, and it is doing it actually, to justify its proposal on the basis of the subsidiarity principle that was recalled yesterday, but there is no early warning mechanism as it applies to legislative proposals for EU free trade agreement. So there is a mismatch from an EU law perspective from the viewpoint of the powers of national parliaments. A mismatch that is not balanced by national law, in the sense that, generally speaking, national parliaments do not enjoy specific scrutiny power vis-à-vis national governments as for international agreement negotiated and concluded by the European Union, which means that the traditional process of scrutiny applies. The same that applies for legislation, but without, of course, the early warning mechanism at the EU level. Then the question is, of course, how national parliament can oversee negotiation without specific procedure and specific powers for it. The prerequisite is, of course, the possibility to accede the negotiating documents. And that is the central element in the first part of the presentation. To what extent national parliament have access to confidential documents, to what extent they can influence the government's position in negotiation. There is a very interesting survey conducted by the Council and by COSAC, two parallel surveys, on the distribution of Council documents to national parliaments. What shows these surveys, to cut the long story short, it's quite a predictable conclusion. There is an inverse proportion between the security classification of documents and the number of documents that are circulated by national governments to national parliaments. As I said, it's quite predictable. The numbers are very interesting. 70% of chambers across Europe are provided access to limited documents. Whereas only 9 member states grant access to documents that are classified as EU confidential, so typically consolidated text and so on and so forth. Subject to very stringent conditions, we only have basically 3 parliaments that can have more deepened access on a more stable and structural basis to confidential documents: the Bundesrat, the Austrian National Rat, and the Swedish Parliament. It is interesting to note that, to a certain extent, TTIP has been a game changer in that, in the sense that we all know that Transparency Initiative taken by the Commission in November 2014 which was aimed basically at making, first of all, public all the EU negotiating text, so the formal negotiating proposals, not all actually, but a large part of it. Secondly, to review the classification of documents, so to make a greater recourse to limited documents instead of restrained, so confidential documents or restricted documents, and to grant a broad access to negotiating text and also consolidating text for MEP, so the famous secure reading rooms. This transparency strategy has been followed, that's where it's relevant for the whole EU trade policy, in October 2015 by a more general initiative within the framework of the European Commission Communication Trade for All. Basically what the Commission said in that communication was, first of all, to invite the Council to disclose all FTAs negotiating directives immediately after their adoption. Secondly, and that's more interesting of course, to extend to other free trade agreements the TTIP practice of publishing EU text online. And finally, there's also a very interesting point, although it's not applied yet, to publish the text of the agreements immediately without waiting for the legal revision to be performed. So all in all, it seems that interesting perspectives are opening up for national parliament for two main reasons. Of course, Council is probably not going to disclose all FTAs negotiating directives, but the other 2 points, so the idea that you review the classification of documents and the fact that you publish your position, your EU position, since the very beginning, de facto make public also the content of negotiating directives decided by the Council. It's not only my observation, it's also the position taken by the Commission itself. So if you combine these two, national parliament should have a better access to the bulk of negotiating directives. And that was precisely what national parliament asked through COSAC since 2014 on. The point is, even assuming that this good practice, this best practice, will apply to other future trade negotiations, there are still shortcomings as for national parliament involvement in the negotiation of EU FTAs, stemming from basically two asymmetries. There is a first asymmetry in the degree of transparency and information right that is both vertical, that's for sure, in the sense that there is an asymmetry between the European Parliament rights, duty to be informed, access to documents and so on and so forth, and the one enjoyed by national parliament. But that is acceptable under an EU law perspective, I think. But the point is there is also an horizontal asymmetry between national parliament in the degree of transparency and information rights. And it was demonstrated by the way in which national parliament implemented the council procedure for the establishment of reading rooms for accessing TTIP consolidating text in member states. So in principle, TTIP consolidated texts are accessible also for member of national parliaments, but when you see how member states have implemented this access through secure reading room, there is a big difference between a member state and another member state. The second important asymmetry is in the degree of parliamentary involvement in overseeing executive. What do I mean? There is no virtuous circle as the one created by European Parliament between information and the exercise of veto over the conclusion, and in the case of national parliament, ratification of the agreement. Why so? For legal reasons, there is no obligation as the one provided in the framework agreement between the Parliament and the Commission to take due account of European Parliament comments throughout the negotiation. There is no such an obligation at the national level, but it's interesting to say that there is also a lack of political will of national parliament that is emerging from COSAC surveys in the political steering of national governments. So there is not only a legal problem, but it's also a political unwillingness to do this to construct this kind of virtuous circle. What are the possible solutions? Very briefly, there is an outdoor solution, if you want. The idea to apply, by analogy, the subsidiarity control that is in place for legislative proposal to proposal related to the negotiation of EU FTAs. The problem is there is no legal basis, in my view at least, to do such a thing, in a sense that if you look at Article 352, that is the only way to apply by analogy to something that is non-legislative, the early warning mechanism, it is explicitly provided for under Article 352 that all the proposal falling within the flexibility clause are going to be subject to the subsidiarity control. So it's difficult to see how this could be applied by analogy to something that is not connected at all to the legislative process, but I can return to that. There's also a question of timing that runs counter this point, in the sense that of course, to apply early warning mechanism means that you determine ex ante the mixed nature of an agreement. Legally speaking, as we saw yesterday, that conflicts with the dynamic distribution of implied external competencies between EU and member state, but also from which, of course, could charge in the course of negotiation, given the timing of negotiation, but also from a political perspective, I think it's not wise in the sense that it hampers the EU negotiating position. It exposes the Union to the risk, the fact of determining mixity from the very beginning, to the risk of being outmaneuvered by the contracting party by means of bilateral negotiation, informal of course, with a blocking minority of member states. So there is also a political problem. Then, of course, there are soft law solutions. Notably, the best solution, I think, is to resort to a more structured form of interparliamentary cooperation. It has already been done for TTIP. As I said, the idea of opening secure reading room is precisely to take a best practice developed by the European Parliament in the framework agreement with the Commission in the second annex of that agreement, and to transpose it to the national level. The point is, there seems to be no consensus, if you look at the 23rd biannual report of the COSAC, that is quite clear, no consensus among national parliament on how to institutionalize this form of interparliamentary cooperation. So it is an open question. So more briefly, the second part of the presentation. What is the role? And of course, I have to sum it up because of time constraint. What is the role of national parliament in ratification? There are at least three aspects. Of course, one is how national parliament can influence the decision on the signing and conclusion. So how they can influence national governments in the council. Secondly, how they can influence provisional application. Thirdly, what's the role of national parliament in ratification? I will focus on the second aspect, although I know that in the afternoon there is a session dedicated to it, so I will focus on it from the perspective of national parliaments. I would just want to add a few words on the first kind of national parliament intervention. So how national parliament can control the council via member state representative. I think it's interesting to note that the Lisbon Treaty has introduced, the new article, if you look at it in the joint reading of Article 207, paragraph 3, and 218, of course, has introduced a sort of reverse majority voting mechanism, in the sense that if you vote the Commission proposal, that in principle should be in favor of, for instance, EU-only agreements, you vote by qualified majority voting. Otherwise, if you want to amend the Commission proposal, in view of Article 293, paragraph 1, you have to do it by unanimity. That is to say, if you want to modify imperieus, typically by adding, that was treated by Germany and France in the CETA negotiation, to include all member states as contracting parties. So you want to amend the Commission proposal, you must find a common accord between member states. So there is an incentive to not to modify Commission proposal, and it also reflects this incentive on the position of national parliaments vis-à-vis national government. Provisional application. What is the principle? Since EU FTAs are concluded as a bilateral agreement and member state and EU are single party, of course, in principle, I will skip all the normative background that you all know, I think. National parliament, if a national parliament notify its refusal to ratify the agreement, then this should trigger, in principle, the termination of provisional application, unilaterally and ex abrupto. And that is precisely the position of some member states, Germany, Austria, Belgium, Poland, if you look at the statements attached to the Council decision authorizing the signing and provisional application of CETA. And there was also a famous incident recalled by Alan Rosas, the Grappa incident, in which precisely Italy was trying to do so. So trying to stop the provisional application of the agreement between South Africa and the European Community. It is a tempting avenue for national parliament, not only vis-à-vis the union, but also vis-à-vis national governments. It is a way to assert national parliament prerogatives against the executive. The point is, I will cut the long story short, from an EU and international law perspective, there is no autonomous, unfettered, automatic right to unilaterally terminate the provisional application on the part of a national parliament. This is because of a question of competence for the provisional application of exclusive EU competence. It's also a question of primacy, in the sense that we have a Council decision, and of course, it is by Council decision that we can amend that kind of act, not by a national legal act. And then, of course, there is a principle of lawyer cooperation. And I just quote the Lyon point of view on that. There is the principle of lawyer cooperation, the duty of lawyer cooperation is a function of the nature of EU competence at end. So if you are looking at the exclusive competence, I think one could theorize not only a duty to inform, but also a duty to abstain from terminating provisional application. These findings are corroborated by international law. Once more, to sum up, I think it's very interesting to look and to apply by analogy the regime of international responsibility for mixed agreement, that is in principle a regime based on joint responsibility of the party. That is to say, if you apply the same regime that applies to obligation flowing from a treaty to the rights stemming from the treaty, including the right to terminate provisional application, this, in the end, you get the indivisibility of the EU party, regardless of the internal division of competence, apart from the case in which it is expressed by means of a declaration of competence. That is not the case for EU FTAs. And this is confirmed by the practice if you look at the Council and Belgian statements attached to the CETA. What those statements tell us, first of all, that both Belgium and Council agrees that it should be the Council to terminate a provisional application. And that couldn't be taken for granted before. And secondly, they leave open the possibility for national executive and parliaments to reconsider national decision. So, in light of the procedural constraint to which the Council decision is bound, qualified majority voting, absence of any time limit, I think that there are counter limits, if you want, to the national parliament power to terminate the provisional application. So to conclude, some remarks, very briefly. First of all, mixity is there to say, as I said, national parliaments are going to exercise an ever-growing role. The proposed solutions to avoid a de facto veto by national parliaments in the ratification of the agreement, partial ratification, incomplete mixed agreement, I think in the afternoon we'll touch upon that, presents various difficulties, in my view, legal and practical. And therefore, mixity brings about a paradox. In practice, it is meant to be something that enhances the democratic legitimacy of the union trade policy. In practice, it exposes the EU to a certain number of democratic imbalances. Blackmail by a single member state, so nationalization instead of collectivization of decision-making, formal equality among member states instead of proportional representation of member state citizens by means of the European Parliament. Hopefully, this democratic imbalance is to a certain extent balanced, sorry for the trick, by the counter limits I mentioned to the role national parliament exercise in determination of provisional application, which from a democratic perspective are all the more justified given the fact that the practice according to which the European Parliament de facto has a veto power on provisional application since the decision of provisional, the entry into force of provisional application is made contingent upon the vote, the EP consent on the conclusion of the agreement. The fact that there are this counterbalance seems to suggest that the future of EU free trade policy rests on provisional application. That, of course, is not acceptable because of the degree of legal uncertainty that brings about provisional application. So my suggestion, to conclude, is that it seems convenient for both the EU and member state, in order to avoid the veto right over ratification and this legal uncertainty flowing from provisional application, to anticipate the possible national vetoes in the ratification process by involving, on a more stable and structural basis, national parliament in EU FTAs negotiation. Paradoxically, the main obstacles does not come from the traditional resistance of national executives to involve the legislative power in an executive prerogative, but in the willingness, in the absence of willingness, of parliament, national parliament, to exercise their overseeing function. And therefore, I think the European Parliament should serve as an example of best practice in building upon limited parliamentary supervisory power to gain more power, to shape more democratic decision-making, also at the national level, ultimately trying to influence the outcome of negotiation. Thank you.